Hello, everybody. Good evening. Good evening. Hello, hello. Welcome. Welcome in. Hello. Good evening, Frank. I have us set to sub chat only because, the trolls. We've had some really big troll issues, so I thought I'll just put the sub chat on so everyone can come and hang out, but then our moderators don't have to be overwhelmed. So, welcome in. Welcome in. We're going to go through the New York sentencing order. Sentencing order. There we go. Hello, hello. Hi, Stacy. Welcome, welcome. Hello, Estelle. Welcome. Yes, Friday, of course, Rich. Welcome in. Happy to make it there. Yes, I know, exactly. There's some really interesting bits in here. Judge Merchan is really setting precedent for us here, and I think he realized that in how he wrote this. So, all right, TikTok, thank you. We got to take a look at it. He made some findings on presidential immunity, which I think is great because it can be cited in the future by anybody that needs it. Hello, Kristen, welcome. Hello, Dee, welcome. It's your Monday. All right. Oh my gosh, I don't know what I'd do if it wasn't Friday today. It's been too much this week, everybody. I cannot believe it. I feel like we've had 2 months worth of news in just a couple of days. Hello, James. Welcome in. So, Judge Merchan, as most people realize, has now set Mr. Trump's sentencing for the 10th of January, which is the same day that TikTok is going to be in front of SCOTUS. So, it's going to be a busy day on the 10th. I think that's all right. Hello, Willie B. Welcome. So we have a twofer there on the 10th. So just as a friendly reminder, we also have Giuliani's trial coming up on the 16th of January. And this is a list of the cases that I am following right now that I'll be giving everybody updates on when the updates occur. So we have Giuliani's cases. He's got multiple cases going. Mr. Trump's appeals. We just got the E. Jean Carroll $5 million appeal answer, but we're still waiting on the $83 million one. So those appeals are there. We also have an interesting piece out of Florida where we still have the 2 other defendants charged with Mr. Trump are still up and running there in Florida. So we'll see what happens with that. Next, we've got the Sean Combs case, which I'm taking a look at that. It looks like his trial is set for March, I think, or May, or I think it's March, actually. So I've not done much on his cases because I'm still gathering information. Also, the Luigi Mangione case, I'm going to say his name wrong, and I apologize for that. But he is on the list. Not a lot going on right now. We did have a bit of a hearing talking about how he has been walked into different places and so on. Also, the Blake Lively civil lawsuit. That's a huge one where she is claiming that there was some harassment going on. And then we have Steve Bannon, who also has a trial coming up regarding his Build-A-Wall fundage and how he dealt with that. So these are my 6 cases my 6 pieces that I'm following in case anyone's wondering what's going on here. So again, I will keep my eye on all of Trump's appeals, and this is one of them. So this is the New York 34 counts of business fraud. And so we went through this whole trial. I took everybody through the whole trial. It was very interesting because New York was extremely generous in allowing the transcripts to be made public for everyone. And that's amazing. It costs a lot of money to actually get transcripts, and rightfully so. A lot of work goes into those transcripts. But New York made it available to the public, saying, we thought this was really important. So we did go through that trial from the voir dire process of trying to choose jurors, and then through each of the witnesses that came in, including Miss Stormy Daniels and Michael Cohen, which were probably the 2 big name people that had been pulled in as witnesses. So that case was decided by a jury, and they did find him guilty of all 34 counts of business records fraud. So just as a quick reminder of what had happened here. So again, each one of those counts was a different record. And on that record, misinformation or false information had been taken down and put into the books. So you can't do that in business, especially in New York. They're going to come for you. And that's what they did. Now, this, of course, is the criminal case. Mr. Trump's case with the AG, which is like $400 million is still on appeal at the moment, but that's more of a civil case. That was a bench trial in front of, oh my gosh, his name just left me, everyone. Oh my gosh, it just flew away. What was this? Engoron. Oh my gosh, I was going to say, if I couldn't remember his name, something wrong with me. So Judge Engoron had presided over that case in that bench trial. So that's still going. Now, we also have the gag order put into place here, which is very specific, it's very narrowly tailored, where Mr. Trump cannot be making statements to kind of harass or intimidate the witnesses or the court staff or attorney staff involved. And that gag order, for lack of a better term, has been upheld. So everyone has upheld that, and it's still off and running. So today, what we just got down from Judge Merchan is his decision and order regarding sentencing. Now, just right a couple of weeks ago, Judge Merchan had come in and had ruled on Trump's motion to dismiss. So Trump had filed a ton of different motions to dismiss to try to get the case done, and Judge Merchan came back in and said, hey, your privilege doesn't work here, and we need to go forward. And then now we have this order setting sentencing for January 10th in order for this case to be resolved before Mr. Trump takes office. So that kind of brings us to where we are at for tonight. Now, again, a lot of the clips are coming out saying, well, we're set for the 10th, but this is an 18-page order, and there's a lot of information in here and a lot of precedent. So I thought it would be absolutely worth our time to go through to read how Judge Merchan put this together, because he's a great writer. He seems to be a great judge. And so it's always interesting to see how our judiciary is going forward. Now, one more thing before I dive into the document, everybody, that I have been taking a look at that came out today. Oh, my gosh. So we have John Roberts, who's the Chief Justice here. He put out his 2024 year-end report on the federal judiciary, right? So because Judge John Roberts is the Chief Justice, he, of course, is the one in charge of all of the federal courts, ultimately. So he put this piece together here on reporting, going all the way back to King George, and giving us a little history lesson on how he feels about the courts. And, here's Alexander Hamilton, here's Chief Justice Rehnquist, who was absolutely idolized by John Roberts. I think Justice Rehnquist was one of the worst Supreme Court Chief Justices that we've ever had. I'm not a big fan of this fella here. Not a fan. But Judge Roberts came in and said, hey, it's going to be bad when he puts a cross in his year-end report. So there's some really interesting things in here. I will be going through this. We'll see if we've got time tonight, but if not, I will be going through it as soon as I can. So perhaps tomorrow. Not King George again. I know, right? King George really left a mark here. So with that, everybody, again, my sub chat is turned on just because of the influx of trolls that we've had over the last few days has been quite excessive. And I didn't want my moderators to have to constantly be blocking and muting people. I wanted them to have an opportunity to be able to hear what's actually going on. So I will go ahead and dive on into this, and we'll do some Q&A as we go as best as I can. To try to answer some questions. If you do have a question and you are not a subscriber, just write it down and ask me on any of my videos. You can just say, hey, I was on your post or I was on your live with Judge Merchan. Here's my question. You can ask that on any of my posts and I'll get back to you on that. So here we go. We've got the people of the state of New York against Donald J. Trump as the defendant. And we have Judge Mershon presiding. Over here, we have decision in an order. This is called our caption, of course. So he is addressing defendant's motion to dismiss the indictment and vacate the jury's verdict. Now, vacating a jury's verdict actually is a very rare situation, and you need to have a high level of incorrect or invalid things occurring in order to pull this to that level. So this is very high level. And he's using section 210.21H and 210.40 sub 1 for anyone looking at the law regarding what he can do to dismiss or vacate a jury's verdict in New York. Here's our indictment number here. In case you wish to look it up, all of this is public record and is available through the New York courts. All right, so let's dive in. Part 1, background and procedural history. On May 30th of 2024, a New York County jury returned a verdict finding defendant guilty after trial on 34 counts of falsifying business records in the first degree. That same day, this court set a deadline for June 13th of 2024 for the filing of post-trial motions. The deadline passed without any filing of any motions. Again, this is a procedural rule. If you miss your deadlines for procedural rules in the law field, you're done. You're toasted. The court set the matter down for the imposition of sentence on July 11th of 2024. However, that date was adjourned to September 18th, 2024, as a direct result of the United States Supreme Court's decision in the matter of Trump v. U.S. On August 14th of 2024, defendant requested an adjournment of sentencing until after the 2024 presidential election. The people did not oppose defendant's request. As a result, on September 6th of 2024, this court adjourned sentencing, if necessary, to November 26th of 2024. Quick side note, everyone. Remember, too, that Mr. Trump had to go through the process of a pre-sentence investigation, or what we call a PSI, where he goes in and talks to a probationary officer who asks a ton of questions, and then that person puts together a report that goes to the state and to the court. So the state has an opportunity again to recommend what sentence they think would be appropriate, and that is what will also be happening on the day of sentencing. So that information is still important, and it's still going to be able to come out at some point. On November 10th of 2024, following the 2024 presidential election, defendants requested a stay of the existing scheduled dates and eventual dismissal of the case in the interest of justice under the U.S. Supreme Court's decision in Trump v. U.S. and the Presidential Transition Act of 1963. On November 22nd of 2024, this court granted defendant leave to file a motion pursuant to Criminal Procedure Law 21041. Which is this one up here, and a motion to dismiss indictment in furtherance of justice. This is kind of our catch-all piece, otherwise known as a Clayton motion in New York, and set a motion schedule. Defendant filed the, here we go, instant motion on December 2nd of 2024. The people filed their response on December 9th of 2024, and defendant filed his reply on December 13th of 2024. And then we have our first footnote here, everyone, and there's a lot of information down in our footnotes, so we'll make sure to catch these. On December 16th of 2024, the court issued its decision in order denying defendant's separate motion to vacate and dismiss pursuant to section 330.31. Part 2, arguments. Oh, thank you, Kaya. Thank you very much. Arguments of the parties. Defendant argues that the Presidential Immunity Doctrine, the Presidential Transition Act, and the Supremacy Clause all require, which is in the Article 6, I believe. So let's remember that. All require dismissal immediately based off of his motion. In support, defendant points not only to his status as president-elect, but also to alleged unlawful conduct by the prosecution, rulings of this court allegedly in violation of defendant's rights, and claimed evidentiary infirmities at trial, which either present either present a legal impediment to conviction or together require dismissal in the interests of justice. The allegations of unlawful conduct against the New York County District Attorney include claims that the district attorney engaged in politically motivated targeting of defendant, unlawfully leaked information about the investigation, tainted the jury pool by making improper public statements, engaged in repeated misrepresentations to this and other courts before, during, and after trial, and suborned perjury from prosecution witnesses Michael Cohen and Stormy Daniels. Defendant also accuses this court of impermissibly presiding over this matter, despite the existence of an alleged conflict of interest and of imposing an unlawful gag order, a reference to this court's order governing extrajudicial statements. So I love how he's just reviewing all of the stuff that Mr. Trump's been pulling this whole time. Like, you did this, you did that, you did that. Pull it to the left a bit more. Sure. There you go. Is that better? Hopefully. Oh, they do look a bit like Elsa. Yeah, or Cinderella. All right, footnote number 2 here. So let's jump down. Footnote number 2 is pretty big. Again, he's going through all of the things that Mr. Trump had tried. So his lawyers are nothing if not thorough on the amount of questions that they raise. Some of the questions are appropriate, some of them are not appropriate, but in the end, they're at least asking those questions. So when all of this is done, I don't think we're going to have a counsel issue, although you just never know anymore. This court recognizes that the lawyering by both the prosecution and defense has been exceptional and spirited throughout the entirety of this case. It is clear that the people have prosecuted this matter to the best of their abilities, and the defense has represented their client zealously. So that's important again. So he can't come back and say he had incompetent counsel. There have, however, been instances when in written submission, counsel has come dangerously close to crossing the line of zealous representation and the professional advocacy one would expect from members of the bar. Ooh, that's a hit. That's a pretty big hit. And officers of the court. And this court has at times made counsel aware of its observations and concerns. Now, however, counsel has resorted to language, indeed rhetoric, that has no place in legal proceedings. Ooh, whoa, are we going to get a sanction in here? Let's see. This is kind of sanction language here. For example, countless times in their motion to dismiss, counsel accuses the prosecution in this court of engaging in unlawful and unconstitutional conduct. These same terms are also peppered throughout the defendant's reply. Those words, by definition, mean criminally punishable. Judge is mad, everybody. Criminally punishable, viewed in full context and mindful of the parties to this action. Such arguments in the broader picture have the potential to create a chilling effect on the third branch of government. Whoa, that's another huge hit. Indeed, Chief Justice Roberts in his 2024 year-end report, which I just showed you, look at this, here we go, this one right here, on the federal judiciary, felt compelled to address 4 areas of illegitimate activity that, in my view, do threaten the independence of judges, on which the rule of law depends. Number 1, violence. Number 2, intimidation. Number 3, disinformation. And 4, threats to defy lawfully entered judgments. Whoa, he is citing the Chief Justice, everybody. So this is pretty important. Let's make sure we note that. Yeah, this is a pretty big deal here, where he's calling out Mr. Trump's counsel and saying, y'all are out of line, even according to the Chief Supreme Court Justice here. All right. Next, the people opposed defendant's motion, arguing that president-elect immunity does not exist and that the vast majority, oh, thank you so much. Oh, that's so sweet. I appreciate that. The vast majority of defendants' claims involve objections that this court and others have repeatedly rejected. And the people submit alternative remedies short of dismissal, which they argue still respect the doctrine of presidential immunity from criminal process, while at the same time respecting the verdict rendered by a New York County jury. The alternate proposals include adjourning sentencing until after defendant completes his term of office, or the application of the Alabama rule, which would effectively permanently abate proceedings without dismissal or the imposition of sentence. So this was, hello, Upgrade, good to see you. So this is, again, they're citing the people's motion. So what I have noticed with Judge Merchan in this case is that he has been very open to both sides, and many times has come in and said, well, we're doing this, the people are okay with this, so we're going to go and do this. So I think that's a great sign. All right, part 3, the jury verdict. As indicated above, the defendant has been found guilty, oh, thank you so much, of 34 felony counts, the significance of the fact that the verdict was handed down by a unanimous jury of 12 of defendant's peers after trial cannot possibly be overstated. Indeed, the sanctity of a jury verdict and the deference that must be accorded to it is a bedrock principle in our nation's jurisprudence. The right to have a jury make the ultimate determination of guilty has an impressive pedigree. Blackstone describes trial by jury as requiring that the truth of every accusation, whether preferred in the shape of an indictment, information, or appeal, should afterwards be confirmed by the unanimous suffrage of 12 of the defendant's equals and neighbors. And then we're citing a 1995 case here that's also citing the Blackstone commentaries. So it's kind of like an expert on how to go forward in trials. Even an examination of how a jury reached its verdict must be approached with caution, and only extraordinary circumstances warrant second guessing the deliberate process here. Trial by fire. Oh dear. Oh my goodness. All right, here we go. In fact, it is the standard practice in criminal courts in this state to instruct jurors at the start of every trial and to remind them before commencing deliberations that, quote, you and you alone are the judges of the facts, and you alone are responsible for deciding whether the defendant is guilty or not guilty. The practical and policy concerns implicated by these instructions are legion. So again, we've got another Casey citing. As such, arriving at a unanimous verdict, often applying their collective intelligence and experience, reviewing and analyzing evidence is regarded as a hallmark of our judicial system. Citing the Brown case out of 1979, thus it is understandably rare for a trial court to overturn a unanimous jury verdict. So again, this is one of those pivotal pieces that we have in our legal system. We have to have faith and understanding and respect for the jury process. Part 4, presidential immunity from criminal prosecution. So he's kind of been setting everything up. We have a little bit of a history. We have what the parties are arguing. And then now he's going to come in and give us what he thinks that presidential immunity piece means regarding criminal prosecution. All right, so defendant makes clear that the driving compelling factor requiring vacatur of the jury's verdict and dismissal of the indictment is presidential immunity and the supremacy clause, defendant's motion, again on page 54. Thus, the primary issue before this court is whether a president-elect must be afforded the same immunity protections from a state prosecution as a sitting president. So here again is our moment of precedence. This issue, as far as this court can discern, is without precedent. So this is an issue of first impression for New York, for Judge Merchan. Although the parties agree on very little, they both appear to recognize the paucity of available precedent to assist this court in evaluating presidential immunity in the instant context. Though the parties arrive at starkly different arguments, this guidance can be found primarily, everyone, in the cases that we have been going over for 18 months. Trump v. U.S., which is the immunity case, U.S. v. Nixon, which is the Oh, thank you, KMW. I appreciate that. This is a case where they said, Nixon, you got to give the tapes over. Nixon v. Fitzgerald, which is like civil case. So Nixon, you have immunity from being sued for things that you did in your official capacity as president. Clinton v. Jones, where we had a case of harassment, a civil suit against Clinton, and the US Supreme Court said just because you're president doesn't mean you're immune from getting sued. And then Trump v. Vance, which also had to do with this idea of can states go forward to get search warrants and subpoenas and various things for the president, to which the Supreme Court said, yes, they may. So there you go. That's all the cases. The Presidential Transition Act of 1963, the 1973 Office of Legal Counsel Memorandum, which is very helpful, amenability of the president, vice president, and other civil officers to federal criminal prosecution while in office, and the 2000 OLC Memorandum, a sitting president's amenability to indictment and criminal prosecutions. And here's the citation there. The clear concerns confronted by the aforementioned sources, which are detailed in the 2000 OLC memorandum, are referenced by the parties, and referenced by the parties are, and then he'll set this out for us. So he's taken all of the cases regarding presidential immunity, including the one that was just decided this past summer, and he's pulled out all the key points, all right? So number one, the actual imposition of a criminal sentence of incarceration. So these are the issues. Number two, public stigma occasioned by initiation of criminal proceedings. And three, the mental and physical demands of assisting with the preparation of a defense for the various stages of a criminal proceeding. And I think we've got, do we have any more? Nope, we don't. Okay, so just those three. As noted by the Special Counsel's Office in their recent memorandum of dismissal. All right, so this is where where we're going into D.C., where Jack Smith filed his motion to dismiss. The 1973 and 2000 OLC memos addressed only federal cases involving presidents. And he, again, is citing Judge Chutkan here and quoting, as with the 1973 and 2000 OLC opinions, OLC's analysis addressed only the federal cases pending against the defendant. So again, he's saying, look, we don't have any state precedent on this. A fair reading of the scant legal precedent in this area of the law supports that the decisions rendered by the Supreme Court over the prior decades were also focused on addressing federal cases brought against the presidents. With the Vance case, so that again was the most recent case, being the one exception. So we have footnote number 3 here. Let's go take a look at Vance. Though Vance directly involved the matter before this court, the Supreme Court's decision came long before trial commenced. This issue in Vance dealt squarely with a subpoena issued to the president by a local grand jury operating under the supervision of a state court. And then here's the citation. As such, although the doctrine of presidential immunity is discussed within the dicta of that decision, there's nothing directly on point for the issue currently before this court. So I think is really important as well. All right, back up we go. However, it is logical to infer that the 3 concerns expressed in the 2000 OLC memorandum can overlap with criminal prosecutions that occur in state court. The first consideration set forth in the 2000 OLC memo, incarceration as a criminal sentence, carries the same restrictions as that of a federal sentence, i.e. deprivation of liberty. So that's our first piece. Second, the public stigma of criminal proceedings will likely occur in both federal and state courts. So that's number 2. And then lastly, the mental and physical burdens that would befall a defendant assisting in his defense against criminal charges would be largely the same in federal and state proceedings. So he's trying to put together, even though we have no state precedent, it's still, they would walk hand in hand with what would happen in federal court. Tea break, thanks. I've got my tang again tonight. Hopefully I won't get too ridiculous. We'll have to see. All right. They both require such exercises as witness preparation, analysis of discovery material and evidence, and overall trial strategy. Furthermore, and then this is in addition, so we have 1, 2, 3, which are set out here, right? So these are the priorities. And then we have an extra piece he's adding, the balancing of competing public interests, i.e., that of protecting the powers and functions of the executive branch, upholding the rule of law, and honoring the security of a jury verdict, permeate criminal proceedings, not only in federal court, but in state court as well. So he is really using this like, is it spicy tang? That's funny. No. But again, he's using this as an example. He's like, look, they've already ruled on federal cases. Let's go ahead and apply this same standard to state cases. I don't see why we can't. Next, the people's response on page 6 is government's motion to dismiss. So they're already arguing this out in their motions. Therefore, the court applies the same balancing of competing public interests to the instant state proceedings in its analysis of defendant's motion. So that's the standard he's using. He's using the federal standard because nothing has been set for states. So he's just putting in and saying, look, let's just use what we already have for federal court. Part 5, President-elect immunity from criminal prosecution. So the first precedent he's setting out is that state courts will deal with this the same as the federal courts. Next, he's going to come in with this idea of what does a president-elect have, all right, as far as immunity goes, because that was not addressed in any of the cases, even the one for this summer. There was no addressing a president-elect situation. Applying the guidance of the aforementioned sources, this court finds that presidential immunity from criminal process for a sitting president does not extend to a president-elect. So this is it. This is the precedent he's setting. No one else in the U.S. has ever said this, all right? To begin, the Constitution dictates that only a president, after taking the oath of office, has the authority of the chief executive. A president-elect does not. Accordingly, a president-elect is not permitted to avail himself of the protections afforded to the individual occupying the office. And then we have our footnote 4 here. Undoubtedly, the transition period between election and the taking of presidential oath is one filled with enormous responsibilities. Yet, even defendant in his motion refers to presidential immunity as one relating specifically to a sitting president, no fewer than 33 times. So he's saying, look, defendant, you already wrote in your brief that it has to be a sitting president. So there you have it. That's interesting. All right, this finding is consistent with U.S. v. Williams, where the D.C. Circuit Court of Appeals held that Presidential Transition Act of 1963 does not confer official status on a president-elect. The D.C. Circuit Court further held that an act provides money and office space to the president-elect's transition team, but does not and cannot deem any of the president-elect's actions, quote, official, before he or she complies with the oath and affirmation clause. So until you're sworn in, you do not have the protections of a sitting president. Right, exactly. All right, so turning to the 3 concerns identified above, which we were just talking about, beginning with the second one, the case at bar is well past the initiation stage, and whatever threat of public stigma for criminal prosecution that might have existed has long passed. Indeed, one of the defendant's most frequent arguments is that this court should defer to the will of the citizenry who recently re-elected him to the office of executive, notwithstanding an actual guilty verdict in this case. Thus, whatever stigma that might have existed will most certainly not interfere with defendant's ability to carry out his duties, both as president-elect and as sitting president. So here's where Judge Merchan's like, they don't care. People who voted for Mr. Trump, they don't care that he's having some criminal troubles. Oh, Judge Merchan, a Cornetka. Yeah, this is Judge Merchan. So the third concern addresses the mental and physical demands of defending against a criminal proceeding. To be clear, neither the United States Supreme Court nor the Office of Legal Counsel in either their 1973 or 2000 memoranda were concerned solely with the time demands of mounting a defense upon a sitting president. Citing the Clinton v. Jones case, the fact that a federal court's exercise of its traditional Article III jurisdiction may significantly burden the time and attention of the chief executive is not sufficient to establish a violation of the Constitution. Remember, the Clinton case was a civil civil case, and then pulling Vance in, rejection of defendant's contention that diversion occasioned by a state criminal subpoena imposes an equally intolerable burden on a president's ability to perform his Article 2 functions. And then we're quoting, criminal proceedings against a president in office should not go beyond a point where they could result in so serious a physical interference with the president's performance of his official duties that it would amount to an incapacitation. So I think, one of the things they're trying to say is like, if he needed to fly somewhere and the court's like, nope, you have a hearing on this date at this time. So that would be a significant interference, right? So the president's like, hey, I'm going to Greenland to check some things out. And so the court's like, nope, we're going to go and have some proceedings that day. That's what we're discussing here. So we've got the memo as well, referencing the distinction between the demands on a sitting president's time for a civil trial versus a criminal trial, which may be mitigated by skillful trial management. Meaning this could be cleared up if we're careful with our calendars. In fact, a sitting president is subject to impeachment proceedings, civil litigation, and service of criminal. That's right, don't forget everybody, under Clinton v. Jones, Mr. Trump can be sued whilst in office. So criminal process, including subpoenas, all of which impose time demands. So Merchan's just reminding, like, hey, we have other things that the Supreme Court does allow, and those do take some time. The greater concern noted by these same sources is whether the burden impedes on a sitting president's ability to perform his constitutional duties, which again, implied or expressed, we don't know. Defendant analogizes that the same concern applies equally to a president-elect, arguing that the demands on his time to appear at any sentencing would be so significant as to impede his ability to prepare for his constitutional duties during the transition period. This court is not persuaded. So again, we're setting some precedent here. Having addressed and resolved all matters brought before this court and the verdict, now more than half a year behind us, all that remains outstanding in this case is the issuance of the decision and the imposition of sentence. Scheduling sentence is a function that remains exclusively within the purview of the trial judge and can be easily set down for a date and time certain to minimize disruption and inconvenience, provided that applicable statutory obligations are met. So he's saying, look, I can set this for any time, so why don't you guys give me a date that works for you? And then we have footnote number 5 here, talking about CPL Article 380 sets forth, among other requirements, that sentencing must be pronounced without unreasonable delay and afford time for the preparation of a pre-sentence report, which was completed months ago. So again, we might see that at some point. Bent over backwards to yeah, exactly. I think Judge Merchan has been very generous, and I think he would be this generous with anyone. So I don't think it's just because he's Mr. Trump. I think Merchan just processes things that way. A defendant argues that Special Prosecutor Jack Smith's decision to dismiss the defendant's federal indictments is evidence of a mandate that all criminal cases pending against the president-elect must cease immediately. The vastly different procedural posture of the instant case renders any comparison to special counsel's indictments unpersuasive. So, he was saying, well, Jack Smith dismissed. Why can't you guys dismiss? And Merchan's like, we're talking about apples and oranges here. Further, the defendant now claims this court cannot and must not sentence defendant. The record is clear that defendant not only consented to, but in fact requested the very adjournment that led us down the path we are on. As the parties are aware, it was on defendant's application without opposition from the people that sentence was adjourned until after the presidential election. Any claims defendant may have that circumstances have changed as a result of defendant's victory in the presidential election, while convenient, is disingenuous. Defendant has always pronounced, since the inception of this case, confidence and indeed the expectation that he would prevail in the 2024 election, confidence that has proven well-founded. Ouch. This is an ouch moment. That he would become the president-elect and be required to assume all the responsibilities that come with the transition were with the transition were entirely anticipated. Thus, it's fair for the court to trust that his request to adjourn sentencing until after the election carried with it the implied consent that he would face sentence during the window between the election and taking the oath of office. The Supreme Court's decision in Trump has delayed sentencing, not precluded it. So that's really another piece as well. The first concern relating to incarceration is addressed in Part 9 below. So we will get into that. You may exactly right, VC, exactly right. All right, so we're going to dive next into the motion to dismiss the punishment here. So just 1 minute. His arrogance was used. Well, exactly. It's like, hey, you agreed, you consented, man. So I think the court looks at consent much differently than Mr. Trump. Part 6, motion to dismiss indictment pursuant to Section 210.21 H. Yeah, that's an H. Defendant presents this court with the novel theory of president-elect immunity as it applies to a Section 210.21H, arguing that such immunity presents a legal impediment to conviction. For the reasons stated above, this court remains unpersuaded that president-elect immunity is the law, and thus neither that doctrine nor Supremacy Clause or Presidential Transition Act present a legal impediment to imposition of sentence. Alternatively, defendant seeks, in essence, a form of retroactive immunity. Both of these theories are briefly addressed below. And I think that that's pretty accurate, right? So he wants to kind of use that immunity to go back in time. Essentially, what the defendant asked this court to do is to create or at least recognize two types of presidential immunity, then select one as grounds to dismiss the instant matter. First, defendant seeks application of president-elect immunity, which presumably implicates all actions of president-elect before taking the oath of office. Again, this whole argument, we're going to need to pause for a moment. This whole argument that you have immunity as president-elect, again, is a situation of first impressions. Yes? Yeah, wintry out, everyone. Thus, he argues that since no sitting president can be the subject of any stage of a criminal proceeding, so too should a president-elect be afforded the same protections. Defendant's memo on page 35. So second, as the people characterize in their response, defendant seeks an action by the court akin to a retroactive form of presidential immunity, thus giving a defendant the ability to nullify verdicts lawfully rendered prior to a defendant being elected president by virtue of being elected president. That's a big one. That would be pretty big. It would be an abuse of discretion for this court to create or recognize either of these two new forms of presidential immunity in the absence of legal authority. The defendant has presented no valid argument to convince this court otherwise. Binding precedent does not provide that an individual, upon becoming president, can be retroactively dismissing or vacating prior criminal acts, nor does it grant blanket president-elect immunity. This court is therefore forbidden from recognizing either form of immunity. Yeah, when you've never heard no before, exactly. Sorry, everybody, my hair just fell down. 1 moment, please. I gotta put Mufasa back. Get my lion's mane sorted. All right, there we go. Sorry about that. Here we go. So, part 7. Oh my goodness, the Clayton motion. So let's walk down this road here. In addition to this claim that presidential immunity and the Supremacy Clause demand dismissals as a matter of law, he separately argues that president-elect immunity and Supremacy Clause are factors this court must consider in connection with his motion to dismiss pursuant to Section 210.41 in furtherance of justice under the court's discretionary authority. 210.41, also known as Clayton motion, sets forth 10 factors a court should consider individually and collectively when exercising its discretion whether grant whether to grant a motion to dismiss in the interest of justice. So that's kind of helpful, actually, because in the interest of justice, as we all know, is this huge, vague phrase. And so we've got a case here. This is why they're calling it the Clayton case, New York case, obviously, that's setting out different pieces of a test. So here's the first one here. The factors are as listed. First, the seriousness and circumstances of the offense. So we have to keep all of these in mind as we go through and figure out how Mershon's going to rule on this case. B, the extent of harm caused by the offense. And again, as we go through these factors, everybody, you have to really put some blinders on as to everything else that's been going on with Mr. Trump. You have to only look to the four corners. I'll call it the four corners of the verdict, right? So we're just looking at the circumstances surrounding the 34 counts. Nothing extra, all right? Just focusing on that as we go through each piece of this test here, all right? It's quite a gauntlet. I agree. Which part of noticing not understand? Probably all of it, all right? So the extent of harm caused by the offense, here, so again, the offense being falsifying business records, the evidence of guilt, whether admissible or inadmissible at trial, so evidence is overwhelming. D, the history, character, and condition of the defendant. So this one, I guess we could take a look at the history, character, and condition of the defendant. We have to be careful when we deal with character issues, but all right. E, the exceptionally serious misconduct of law enforcement personnel in investigation, arrest, and prosecution of the defendant. I don't know that we're really in that particular area. F, the purpose and effect of imposing upon the defendant a sentence authorized for the offense, right? So what's the reason why he's being sentenced? G, the impact of a dismissal upon the confidence of the public in the criminal justice system. And I think that's our winner. I think that's our winner chicken dinner right here. The impact of a dismissal. This could be it. This could actually be the end of any kind of faith in the criminal system. If this case were to just get knocked out. H, the impact of a dismissal on the safety and welfare of the community. Where the court deems appropriate the attitude of the complainant or victim with respect to the motion, and any other relevant fact indicating that a judgment or conviction would serve no useful purpose. So I think this is another one here. So next, we've got dismissals in the interest of justice should be issued sparingly and granted in the rare and unusual case where it cries out for fundamental justice beyond the confines of conventional considerations. Citing case law, such motions should be granted only where there is some compelling factor, consideration, or circumstance clearly demonstrating that conviction or prosecution of the defendant upon such indictment would constitute or result in injustice. Citing for the case law. When considering such a motion, a court must refrain from usurping the role of the jury. So at the end of the day, what the jury holds is what's important. And if you overturn a jury, you better have a really good reason for that. BC. That's so funny. All right, a motion filed pursuant to Section 210.41 must normally be made within 45 days of the arraignment. So he missed that deadline. Notwithstanding that limitation, defendant requested leave to file this motion following the 2024 presidential election. As defendant's status as president-elect presented a factor for consideration that did not exist within 45 days of his arraignment, this court granted that request. So that's generous. Defendant presents additional factors which he claims, when applied to the 10 enumerated categories, individually or collectively, support the necessary outcome. To be clear, defendant's claims, other than those related to presidential immunity from criminal process, relate either to evidentiary issues or prosecutorial conduct which occurred prior to indictment, before trial, or during trial, and should have been addressed in a properly and timely filed Clayton motion. So this is where the judge is like, dude, y'all didn't file this properly. But I'm going to give you, the benefit of the doubt. Nonetheless, This court will address the claims on their merits as defendant argues that presidential immunity and the Presidential Transition Act, individually or taken together with the traditional Clayton factors, warrant a dismissal in the interest of justice. So now we're going to get into his analysis of whether or not the special situation here actually will add up to overturning a jury's verdict, which of course is going to take a lot. All right, part 8, application of the Clayton factors. I hope someday, everyone, one of my wishes, and I just want to share this with everybody, one of my wishes in the future of the legal landscape is that we get rid of these Roman numerals because it's annoying. I'm just going to put that out there. All right, here we go. This court will now apply defendant's claims to the Clayton factors. A, the seriousness and circumstances of the offense, and B, the extent of harm caused by the offense. So let's go through that analysis here. Defendant argues that the 34 counts of falsifying business records in the first degree, in this case, pale in comparison to the seriousness of the majority of the street crimes prosecuted in New York County. Whoa! Wow, Mershon's mad. And that, coupled with the decisions of other agencies, do not pursue charges against the defendant, provides context for this court to consider factors A and B. Ouch, everybody. All right, this is a hard burn right here, legally. Woo, that violent crimes are or are not prosecuted in this same courthouse does not negate the seriousness and circumstances of the instant case. Seriousness and harm are not measured solely by the level of violence inflicted or the extent of financial harm. Seriousness can be gauged by considering the significance of the act under the unique circumstances of the case, as well as by harm to society as a whole. Citing case law. So he's saying, look, dude, we got to just look at what you did. We're not going to look at other people. Nature of the crimes charged militate against rather than in favor of dismissal. Rejecting motion under factors A, B, D, F, G, and H in the prosecution against New York's state assemblyman for 76 counts of offering false information for filing as the harm was in the impairment of public trust. Here, 12 jurors unanimously found defendant guilty of 34 counts of falsifying business records with the intent to defraud, which included an intent to commit or conceal a conspiracy to promote a presidential election by unlawful means. So that seems pretty clear. Oh, thanks, Daisy. Sorry, everybody. Here we go. I need to have a humidifier on me. In the future, I'll have to get that. It was the premeditated and continuous deception by the leader of the free world that is the gravamen of this offense. Ooh, yikes, another burn. To vacate this verdict on the grounds that the charges are insufficiently serious. Whoa, Mershon. Oh, all right. Insufficiently serious, given the position defendant once held and is about to assume again, would constitute a disproportionate result and cause immeasurable damage to the citizenry's confidence in the rule of law. Wow. So I think that's pretty firm statement here. Oh my gosh. Yeah, the judge he's not playing around here. All right, C, the evidence of guilt. So this, again, will be an important piece. Defendant claims that the evidence at trial was weak and argues that the district attorney relied on perjured testimony and evidence introduced in violation of the presidential immunity doctrine. As to the latter, this court recently issued its decision in order, finding that no official acts evidence was admitted at trial. Thus, that argument is meritless. As to the allegation of Michael Cohen provided unreliable perjured testimony, this court presided over the entire trial and sat mere feet. Oh my gosh, Mershon. And sat mere feet from all the witnesses who testified. In doing so, this court had an opportunity to listen to their testimony and to observe their demeanor, and therefore to form an opinion as to their credibility. And having done so, it does not agree with the defendant's characterization of Mr. Cohen's testimony. Oh, all right. He's a hot tamale tonight, everybody. Hot tamale. All right, and then he's citing, he's not citing it. Hold on, the citation's coming up. Moreover, a total of 32 witnesses testified at trial. 32, everybody. I didn't realize there were 32, but that sounds right. And over 500 exhibits admitted, all of which supported the jury's verdict. Oh my gosh, thanks everybody. Thank you. I appreciate that. This claim does not weigh in defendant's favor. Okay. So Mershon was like, the evidence is overwhelming, dude. So good luck with that one. All right, D, the history, character, and condition of the defendant. Ooh, this should be interesting. Defendant argues that his contributions to this city and nation are too numerous to count, and concludes his argument under this section by referencing 2 New York Supreme Court cases, which are entirely distinguishable. So here's number 7. Defendant's reference to People v. Clifford in support of dismissal due to lack of criminal history is misleading. That case addressed Clayton motions submitted as to 4 defendants, 3 of whom had no criminal records. Here, with relief granted only as to 1. The second case involves facts wholly incomparable to the instant matter. All right, so that didn't work out. So that argues not going to work for him here. The court agrees defendant served his country as president and will do so again in a matter of weeks. However, that service is but one of the considerations to weigh under this factor. Despite defendant's unrelenting and unsubstantiating attacks against the integrity and legitimacy of this process, individual prosecutors, witnesses, and the rule of law, this court has refrained from commenting thereupon unless required to do so, as when ruling on motions for contempt of court. Ouch. Here's another. Oh my gosh, that's a pretty significant burn there. However, defendant, by virtue of the instant motion, directly asked this court to consider his character as a basis to vacate the jury verdict. And this court must do so in accordance with the requirements of Section 21041D. Defendant's disdain for the third branch of government. Wow, he's starting off strong here too, everybody. Oh my goodness. Oh my gosh, this ruling's on fire here. All right, here we go. Whether state or federal, in New York or elsewhere, is a matter of public record. Indeed, defendant has gone to great lengths to broadcast on social media and other forums his lack of respect for judges, juries, grand juries, and the justice system as a whole. In the case at bar, despite repeated admonitions, this court was left with no choice but to find the defendant guilty of 10 counts of contempt for his repeated violations of this court's order restricting extrajudicial statements. Findings which, by definition, mean the defendant willingly ignored the lawful mandates of this court, an order which defendant continues to attack as unlawful and unconstitutional, despite the fact that it's been challenged and upheld by the Appellate Division First Department and the New York Court of Appeals, no less than 8 times. Indeed, as defendant must surely know, the same order was left undisturbed by the United States Supreme Court on December 9th of 2024. Ooh, that's the cherry. That's the cherry on top of the cupcake, everybody, right there. Yet, defendant continues to undermine its legitimacy and posts to his millions of followers. Indeed, wow, gloves are off here with Judge Mershon. Gloves are off, everyone. Beware. Oh my gosh. This is not the only instant in which the defendant has been held in contempt or sanctioned by a court. Hold on, everybody. Puzzle piece moments. Oh, my gosh. Oh, did we do it? Okay, we made it. Phew. Hold on here a second. We've lost our flow here. So, all right. So, indeed is the first word. And we'll flip over here. This is not the only instance in which defendant has been held in contempt or sanctioned by a court. And then we have a footnote here. So footnote number 8, for example, defendant has been held in contempt by courts within this jurisdiction and sanctioned by others. People of the state of New York versus the Trump Organization is being cited. Trump v. Clinton is being cited. Oh my gosh. This was where he tried to plead defamation for statements that Hillary made during the election, and the court issued almost $1 million sanction against him. Frivolous lawsuits should not be used as a vehicle for fundraising or fodder for rallies or social media. Mr. Trump is using the courts as a stage set for political theater and grievance. This behavior interferes with the ability of the judiciary to perform its constitutional duty. Ouch. Oh my goodness. That's painful. All right, 8. Oh my goodness. Defendant's character and history vis-a-vis the rule of law and the third branch of government must be analyzed under this factor in direct relation to the results he seeks, and in that vein, it does not weigh in his favor. Oh my gosh! Oh, Rashad, that's hilarious. Look, sure, let's weigh that out, but it's not going to help you. Oh my goodness! Goodness gracious! Band plays during the inauguration. A smooth criminal. Oh my goodness. Well, you never know. You just never know what's going to happen. All right. Distracted. Sorry, everybody. So this is E here, an exceptionally serious misconduct of law enforcement personnel. All right. Defendant next alleges several instances of trial misconduct, including false testimony elicited from the district attorney from Stormy Daniels and Michael Cohen, alleged misrepresentation by the DA for the unavailability of potential witnesses, Alan Weisselberg, an unconstitutional crusade against the defendant, unlawful investigative leaks, and alleged misrepresentations by the DA in the removal proceedings. And then we've got footnote 9 stating, while several of these claims are clearly designated by defendant in support of factor 210.41E, others were raised in earlier portions of the defendant's motion without reference to a specific Clayton factor. Notwithstanding that omission, the court will consider those claims as most appropriately falling under subsection E. Oh my gosh, that's hilarious. So the judge is saying dude, you didn't even plead this correct, but I'll just plead it for you. I'll just help you out. Oh my goodness. I'm curious. Exactly. All right. Defendant's argument that the people committed egregious misconduct by eliciting certain testimony from Mr. Cohen and Ms. Daniels is unsupported, and his arguments mischaracterize the record. This court entertained countless arguments before and during trial regarding the permissible parameters of the testimony of these witnesses, and rulings were made in every instance. If those rulings were violated, objections were voiced, and where appropriate, questions and or answers were stricken from the record. Where necessary, curative and limiting instructions were given to the jury. Notably, the jury credited the testimony of Mr. Cohen and Ms. Daniels and returned a verdict consistent with that finding. Further, this court does not share defendant's characterization of the colloquy. I can't do it, everybody. This is a tough one. If it's got a Q in it, I'm going to struggle. Colloquy sounding the availability of Mr. Weisselberg. The people unsuccessfully argued for the admission of Mr. Weisselberg's severance agreement as proof of his unavailability to the people, which counsel for defendant argued that he, quote, wouldn't be surprised if there ends up being a foundation for a missing witness instruction about the uncalled witnesses being equally unavailable to both sides, end quote. Yikes. Equating an unpersuasive argument with misconduct is a leap this court will not make. Thus, neither of these claims weigh in defendant's favor. Oh my gosh, Mr. Weasel, that's right. Mr. Weasel came back. Remember there was that discussion of, what do you mean we could bring in Mr. Weasel? Can we? And the judge is like, too late, man. No weasels. Oh my gosh. All right, here we go. Oops, one more. Let me grab some tea real quick. All right, here we go. As for the alleged misrepresentations by the DA in connection with the removal proceedings, This court is not aware of such misrepresentations. Thus far, defendants' efforts to remove the case to federal jurisdiction have been rejected. And he tried that like a million times. What remains is defendant's appeal of Judge Hellerstein's denial of his motion for leave to move for removal a second time. So I did go through this ruling as well, where he came in and said, look, none of this is official conduct here. So nope. With respect to defendant's claim of an unconstitutional crusade against him and unlawful investigative leaks, both claims have been raised previously and rejected by this court. And then citing where he's rejected that here, motions in limine, various other things. The claims are equally unpersuasive now. While significant portions of the defendant's motion reference a book by a former DA, assistant district attorney, to bolster these claims, this court is not swayed. That a former prosecutor wrote a book which is critical of the decision of the district attorney, Alvin Bragg, does not render those decisions unethical, unlawful, or evidence of misconduct. True story. True story. I'd have to agree with that. All right, here's F. And we're really coming down to the end here, everyone. So here's F. The purpose and effect of imposing upon the defendant an authorized sentence is the factor we're looking at. Defendants argue that the effects of imposing an authorized sentence violates the presidential immunity doctrine, the supremacy clause, the Sixth Amendment, and the Eighth Amendment, which cruel and unusual punishment for the Eighth Amendment. The Sixth Amendment, I don't know, because he had a jury. He had a counsel. I don't know what he's even saying under the Sixth Amendment. Yikes. And thus, this factor strongly supports dismissal in the interests of justice. In support of that claim, defendant refers this court to his earlier argument in his motion to dismiss Part 1E, in which he contends the legality of deferring proceedings until he completes his presidential term. This court rejects defendant's claims that proceedings with sentencing is precluded as a matter of law. Analysis of this claim pursuant to this court's discretionary authority, which is in italics, which means that's serious, is consistent with and addressed below under factor J. All right, so here we go. The judge is pretty amazing. This is a pretty amazing decision here. All right, G, the impact of dismissal upon the confidence of the public in the criminal justice system. This is the one I'm like, that's a pretty big one right here. That's, we've already had Dobbs where we're like, Supreme Court, you're jacked up. And now it's like, what are we going to do here? Defendant argues that a dismissal will improve public confidence in the criminal justice system because anything short of a full dismissal will interfere with the presidency. Oh my goodness. This court's perspective is different. Thank goodness. To begin, he claims that the New York County jury pool was tainted and that he was unable to select an impartial jury. And then we have footnote 10 here. Referenced within this category are defendants' arguments regarding D.A. Bragg's extrajudicial statements during the pendency of this case, publicly arising from the prosecution of the Trump Organization, Chief Financial Officer Alan Weisselberg, and public statement by witnesses Michael Cohen and Stormy Daniels. Defendant raised the same issue previously in a motion for a further adjournment based on alleged judicial pretrial publicity. That motion was denied on April 12th of 2024. Further, this court presided over the voir dire and nothing raised during that course of jury selection process gives this court pause regarding the jury pool. And while defendants repeatedly refers to that stage of this process when more than half of the potential jurors purportedly self-identified as unable to be impartial as proof of an unfair system, this court construes that very event entirely differently. First, all right, here we go. We're getting another outline format. We love that for us. First, it is standard practice for this court to ask prospective jurors at the start of every trial to self-identify if based solely upon what they've heard about the case. Up to that point, they have reason to believe they cannot be fair and impartial, or if they cannot serve for any other reason. Thus, while not particularly significant, we do not know how many prospective jurors self-excused because